Okay, so now we move on to the governing of a company. So far, we've looked at just some rules that the Companies Act has with regards to how you should be running your business. So when we're looking at the governing of a company, we're looking at it from the perspective of your directors and your shareholders. Because ultimately they are the people who govern this company. Okay, so earlier we mentioned that directors have been put in place to dilute the control that shareholders have, because ultimately they want profit, and therefore they could do things that are not in the best interest of everybody else in order to get that profit. So now we bring in another party, which is directors, to try and make sure that you're keeping the shareholders in check in order for them to get their profits. But directors now want salaries, and so they have to also be kept in check. So these two bodies are now going to have to be kept in check by each other. Okay, these two governing bodies are going to be monitored by the other party. All right, so when it comes to directors now obviously have their own motive, so they are going to be responsible for making or for authorizing certain decisions that affect the shareholders. And obviously it can't all be one-way traffic, so from the other side of things, the shareholders are going to be responsible for making and authorizing certain decisions that affect the directors. And so now what we've got is accountability between each. Look, there are going to be certain decisions which are very complex that both of them will require authorization in order for that decision to take place. And so in a few minutes we're going to look at the certain transactions that directors and shareholders are responsible for authorizing. Before we get to them, I just kind of want to give you a summary so that you can start to understand how each will be held accountable to the other. And then as we get into the decisions, you'll see how it's passed. But like I say, how can a director have some sort of hold or keep the shareholders in check? Well, directors are able to decide who becomes a shareholder because directors authorize the issue of shares. So they can see, we will issue these shares, and obviously then to the shareholders, and therefore they get to decide who becomes a shareholder. Shareholders then obviously need to be able to decide who becomes a director. So shareholders are able to appoint and remove directors. So they are able to authorize the appointment and removal of directors. So one for one. Then, what do shareholders get as a result of having shares? They would get dividends. So directors are able to authorize distributions by the company, and dividends are a distribution. But we need a one-for-one here. So what do directors get? They get remuneration. And therefore, our shareholders are able to authorize our directors' remuneration. Okay, so as we're seeing, one for one. Then there's certain decisions that are considered very complex, very important, potentially affecting both. And those decisions require both the directors and the shareholders' approval. So what are those? Financial assistance, either for the purchase of shares, and that then obviously affects shareholders, or financial assistance to a director, and that obviously affects your director. Both need to now give authorization for those. Also, if there is an issue of shares to a director. Issue of shares is generally a director's responsibility, but now who is going to be getting those shares? A director. So they can't be responsible, because then they're going to obviously do it in their favor. And so the two will now have to authorize. Okay, so that's just a summary of some of the very important decisions. We'll look at other decisions and we'll see how each party has their role to play in that decision. But these are the very common ones. So guys, just so we can have sections next to it, this is section 44, this is section 45, this is section 41. Issuing of shares is section 38, and distributions is section 46. Directors' remuneration, section 66. Appointment and removal of directors, 68 and 71. Okay, so just an idea of the sections and transactions we are about to cover. Guys, just before we get into the details, just so you understand, directors make a decision by the majority voting in favor at a meeting. Okay, that's how they make a decision. The majority must vote in favor, that's it. For your shareholders, they have two types of requirements for a decision to be made. And either they will need to pass an ordinary resolution, or they would need to pass a special resolution. An ordinary resolution is the same as your directors in that the majority voting rights at the meeting must vote in favor. So that means greater than 50% must vote in favor. But for your special, it's 75% or more must vote in favor. So we're going to see certain decisions which require a lot more of the shareholders to be on board, and then decisions which just require that the majority at that meeting votes in favor. Okay, but we'll get into that. But just so that you can see, your shareholders are the ones who pass ordinary resolutions or special resolutions. And it's the same thing. It's just about the number that have to vote in favor for that decision to take place. And so a less strict decision, an ordinary resolution will be required, whereas a very complicated decision that affects the business, more shareholders will have to vote in favor and pass a special resolution. As opposed to directors who just pass a resolution by voting in favor. So again, they don't get a different type of resolution, they pass a decision if the majority votes in favor. Okay, so let's start with understanding a little bit about shares and the business before we get into the major transactions and the decisions that each party has to take.